Welcome to the third edition of Understanding Corporate Law with Dr. U K Chaudhary. The first two editions really which focused on the role of NCLT and the IBBI over the last decade or so have received an overwhelming response. In less than 30 days, we have more than 1 lakh views. The first episode has 1,10,000 views, and the second episode has roughly 94,000 views and still growing. So clearly you're liking it, and there is some relevance for all of you to watch this and be able to come up to date on what's happening in corporate law. Continuing the series on NCLT and insolvency, today we are going to look at, in this third edition, the role and the relationship of, what is the current position of the CoC vis-a-vis the RP, NCLT and the CD, and we will then move into various aspects. So let me welcome Dr. U K Chaudhary. Dr. U K Chaudhary, what we've discussed seems to be finding some resonance and viewership among people. So clearly there is the content and your views are being received and watched. What do you have to say about this?
First, Anurag, I'm glad that our discussion is catching up the eyes with the people, and certainly it's very encouraging for me that it is finding acceptance with the audience, and if we can be of any use to educate them, to skill them in the areas of our expertise, it is a real good achievement for BMW Legal, and to me too personally satisfying.
Thank you, Dr. Chaudhary. Clearly, we are a BW Legal World is a platform for professionals, for GCs, for law firm partners, for the legal ecosystem that interacts with business, and hence what you are saying is very relevant. And we are not limiting this just to the BW Legal World platform, but on the main BW Businessworld platform. But today on this third episode, let's focus on the current position of the CoC with respect to the NCLT, the RP and the CD. Let me get top line comments from you on what is the current position of the CoC with the NCLT, the RP and the CD.
Well, the current legal position is very well settled. Over a period of more than 9.5 years, the Honorable Supreme Court in many decisions have already settled the law. So there is, as of now, no doubt that what is the relationship between the Committee of Creditors, its binding decisions on the NCLT, on the corporate debtor and all other stakeholders. Its position regarding the approval of the resolution plans by a successful resolution applicant is also very well settled. Similarly, the position of the CoC vis-a-vis the IRP or the RP is also very well settled. And first let me fill in the audience with that what is the current position. See, the current position, which started with the innovative decision in the Supreme Court in 2018 and followed by the followed by the Kesh Ridhan case, followed by the committee of the SR Steel, followed by GK Mishra case. It has all become very settled that there is one commercial aspect of the CoC. That commercial aspects, when applied, mind reasonably and with full discussion and with following the principle of law, then this decision commercially is binding all the stakeholders, including the National Company Law Tribunal. So I do not see that there is any dispute or any difference of opinion that as of today, the law relating to the binding effect of the commercial decisions of the CoC has any dispute in any person's mind. And in this regard, if I can draw your attention to the various paragraphs which find attention in 2019 and also in 2021 and 23, in the various cases, this issue is well settled. And if I can put it in the short, the decision is that it is the commercial wisdom of the Committee of the Creditors, which is mostly the banks and the financial institutions, which once take control of the discussion relating to that what should be the prospective of the resolution of the debt. Then that commercial decision becomes binding on all the stakeholders, including that there is not much of a scope even for the National Company Law Tribunal to interfere with that commercial.
Then what is the point of involving the NCLT? If the CoC is going to take something and going to be binding on the court, or there is not much scope, it is just being ratified, if I may say, then is there something that needs to change, sir?
I think first let me clarify that it's not a completely that NCLT doing a rubber stamping to the resolution plans which has been passed by the CoC, and a successful resolution applicant has been picked up in their commercial wisdom. However, looking at the language of section 30 of the Insolvency and Bankruptcy Code, it is also very limited jurisdiction of the NCLT that it can go into the question of the commercial wisdom. That is only that if there is something in the plan which is so objectionable that it comes to a violation either of the IB code or it is in violation of any other law of the land. If somebody can point out that kind of an objection, then the National Company Law Tribunal can say that since the resolution plan is in violation of such and such law, we do not approve of it and we send it back for reconsideration to the Committee of Creditors. But according to me, this also falls short of the requirement of the rule of law as is prevailing in the other jurisdiction relating to the insolvency law. For example, in the UK and the United States and some other jurisdiction like Singapore, the commercial wisdom of the creditors' decision is not supreme. It is subject to the rule of law. And that rule of law is that if there is some reasonable cause can be shown to the court that the decision of the Committee of Creditors or the creditors forum has been arbitrary, it is capricious, it is not subject to the principles of natural justice, or there is a major fault in the application of that commercial decision to the given facts and circumstances of the case, then the courts are not completely acceptable to that decision, commercial decision of the CoC. They have their own discretion and they are not completely powerless not to do anything. Therefore, this is where that my professional difference of opinion comes in what the Honorable Supreme Court has laid down a law, which of course, as of now, is binding on me, is binding on all the tribunal, is binding on all the courts in the country, which are subordinate to the Honorable Supreme Court under Article 141 of the Constitution. But that still does not mean that there is no scope for the review, even of the decision of the Honorable Supreme Court. For example, in all jurisdiction all over the world, as far as I have understood the insolvency law is that the insolvency judge is the final arbiter. He is the one who has to decide whether this commercial decision, even for the good of the stakeholders, including the corporate debtor, and whether the value which has been accepted in the commercial wisdom of the CoC, whether it should be accepted as it is or it should be modified or it should be sent back for reconsideration to the CoC. That is what that I would like to see, that there is a scope, and I hope and I see that there must be some reasoning in the coming judgments of the Supreme Court, that it's not always that the bankers or the financial institution which take controls of a forum, which decide about that how much they should recover from the assets of the corporate debtor. That decision must not be lent for final decision to them. It must be left ultimately to the court to find out that is this decision binding or is decision good for all stakeholders.
Sure.
In this regard, I may just say that in SR Steel, when we were arguing before the National Company Law Tribunal and the Appellate Authority, we persuaded the Appellate Authority to make some amendments in the various decisions which ultimately were not clear relating to the distribution of the proceeds of the assets which has been given to the financial institutions and the banks, or the CoC, I should say in short, is that whatever the proceeds come, what will be the distribution of those proceeds must be left entirely in the hands of the CoC. We ultimately persuaded that there must be something in that decision left to the operational creditors, which is a larger body than the members of the CoC. And to that extent, there was an observation by the Appellate Authority in the SR Steel case, where it was taken a decision by the Appellate Authority that it will be very appropriate that the CoC must at least put across something more than what is required in the process of the liquidation cost or the liquidation value. So, the operational creditors, which is the largest body of the supporters of the CD, then the financial creditors must also get some say in the distribution of that proceeds of the coming out of the assets of the CD. But unfortunately, for the operational creditor, this decision was set aside in the SR Steel case by the Honorable Supreme Court. And ultimately, the entire commercial wisdom of the CoC, even in the distribution of the proceeds, was also made that it is binding on all the stakeholders, and if they decide that the operational creditors will get only 1% or 2% of the entire proceeds, that it be.
Sure.
So, to that extent, I will say that these decisions require some review at any point of time. For example, according to me, in my professional opinion, the operational creditors are getting a short change in the entire system or the ecosystem of the IBC, which according to me, in my commercial decision, is not acceptable to all the stakeholders. So, there has to be something done either in the law or something has to be done in the decision of the Honorable Supreme Court, that distribution of the proceeds must not be entirely left in the hands of the CoC. There must be some portion of it either by mandate of law or by a judicial interpretation of the law must be set aside for the operational creditors. And so must be the finality of this decision also must be left in the hands of the National Company Law Tribunal or in the hands of the Appellate Authority. As far as the Honorable Supreme Court is concerned, you know that they have an extraordinary power under Article 142. They can pass any order. They can even pass any order relating to the distribution of the money also, rather than handing it over to the CoC. So, as far as the Honorable Supreme Court is concerned, they have more than the required powers.
So, are you saying that while if we take from what you said in the first episode, in the second episode, you complimented the NCLT and the IBBI for successfully solving the logjam and ensuring that the companies stay active, the banks and the creditors get their money. In some cases, the operational creditors have also got their money. But you said it needs to keep pace. Now, let me ask you directly, the role of the RP or the IRP in some cases is also very crucial, and the relationship of the CoC with the RP is another aspect of this whole insolvency process, which has come into focus. What do you think is the current relationship, and CoC has the powers to, does the CoC have any influence over the removal of the RP even if he or she is confirmed?
Yes, I think this issue is, as of now, is also very settled, but it also requires to be relooked. For example, I'll draw the attention of my viewers that under section 27 of the Insolvency and Bankruptcy Code, the law provides that within 30 days from the takeover by the interim resolution professional, he has to be confirmed, and the confirmation is with the voting right of 66% in confirmation. So, if 66% vote in favor of the confirmation of the IRP, he becomes an RP. But even thereafter, there is an absolute power under section 27 that as and when the Committee of Creditors so feel, and sometime even without a reasonable cause, that 67% of the person holding powers of voting in the CoC can at any stage pass that resolution, place it before the National Company Law Tribunal through the same RP, that now this resolution has been passed, RP need to be changed, so he can be substituted by another RP. And as of now, the law is settled that National Company Law Tribunal has not much to say in such a process. If such a resolution comes before along with the application, it will have no option but to say, okay, change the current RP, and the new RP will be appointed from the list which already coexist with all the National Company Law Tribunal benches. So, they pick up one out of them, so that further procedural time is reduced by referring the matter to the IBBI. And in that process, immediately the new RP will come. But please see that what is the dangerous in this situation. I am not very happy with this situation. I will tell you why. That why I am not personally very happy with this situation. If you let the RP be subject to that cruel mandate of a voting percentage of 66%, then you, by mandate of law, surrendering the entire professional independence of that RP to the working of the CoC. So, let us say that in CoC there is one bank which has a 67% voting. Now, what that bank will not do with that RP? They will put all kind of pressure on him that he should run the CD according to their desires, their wishes. He will say, this is the steps that you should take, this is the way you should find out the successful resolution applicant, and this is the way you should decide, because I am the 166%, I will approve any SRA. So, successful resolution applicant, from deciding up to picking up, this person will call the shots. Now, this is not certainly the intention or the objective of appointing an independent professional to be the in charge of the control of the CD. This was not the intention of the IB code. The IB code therefore has taken that there is a trained, qualified professional known as the resolution professional, who has a decree or a certificate from a recognized institute to take over the control and affairs of the CD. Once he take as a professional, there must be some independence in him. Sure. He should not be subject to the cruel arbitrage of that decision of the CoC that I have 66% more voting right, one or more. I am not saying it could be one bank, it could be one ARC, or it could be 2 or 3 or 4 of them together. But in my professional view, it is not correct to say that a person who has been appointed by the National Company Law Tribunal, who is like a representative of the National Company Law Tribunal, a person who is qualified professional in his own skill and in his known knowledge to run the CD, must look for everything to the CD. And therefore, the CD's affair must be left to him rather than to a kind of a subjective control of 66% voting. Therefore, the word shall in section 27 according to me should be interpreted as may, and under the interpretation of the statute, it is not uncommon. Honorable Supreme Court in hundreds of cases have said so, that if the objective of a section or an objective of the code or an objective of a legislation is such that the shall may be treated as discretionary based upon the court, the shall can also be read as may. And therefore, this interpretation which today prevails, that no, once there is a resolution coming under section 27 placed before the National Company Law Tribunal, then National Company Law Tribunal is bound to accept that decision and change the resolution professional. I may just draw the attention that if this same situation happens even in the United States, the creditors committee or the creditors forum have the same right as we have in the CoC today. That if the majority of the creditors decide that the bankruptcy trustee is not actually, they are happy with him or his working, they can pass a resolution. But that resolution, when placed before the insolvency court, the insolvency court is not bound by that decision. It can, in its own judicial wisdom, can ask for a reasonable cause. He says, show me the reasonable cause that why this bankruptcy trustee need to be removed. So there are the checks and balances, and the court is a not completely rubber stamp. This is the situation that I am not happy about it. I know, I personally can vouch that what a wonderful job the National Company Law Tribunal has done in the last 10 years. So much so that at the cost of the Companies Act 2013, they have promoted IBC. And today we have reached a happy situation that more than about 15,000 cases have been settled just by filing a petition. The petitions are not even heard. The moment the borrower has come to know is the fear of that losing the company, that 15,000 cases have been settled even before admission. Settled even before admission. So you see that this is the happy situation. And this has brought in something like about 4.5 lakh crore to the banks and the financial institutions and the ARCs. So I do not wish that the NCLT should be treated as a paper tiger. It must follow the law. It's a creation of a statute. Therefore, it must follow the statute. But the interpretation of that statute lies with the Honorable Supreme Court. Therefore, I wish that sooner or later the Honorable Supreme Court will relook on this position of section 27, and it will not become completely binding and mandatory that decision of 66% will be followed as it is.
In the case of the
as the case is in the case of removal of the RP or substitution of the RP. They must follow that reasonable clause as the reason or cause required for a removal, as is the case in the insolvency courts in US.
Fantastic. Now, see, you practiced corporate law before the NCLT came in the company law board. You have now 50. This is your 51st year of practicing law. What do you think, in your professional opinion, though legally it is right and it is working to a large extent, what should be done? You've already kind of alluded to some of those. What should be done to make sure that it becomes even better in application than it is right now?
See, as I told you in my first episode also, that some quick amendments are required in the Companies Act. For example, the Companies Act saying that the appointment of the members in the NCLT must not be less than of 50 years of age. I do not find any justification for it. I have given an example that most of the lawyers who practice in the high courts, they become qualified and in fact sometime appointed at the age of 43, 44 and 45 as the high court judges, which is a constitutional position. So if a member of a bar can become a high court judge and hold a constitutional position, I do not see that what is the justification in saying that the NCLT member, judicial or otherwise, cannot be a 45 persons of age. For example, a company secretary, a chartered accountant, a qualified cost and works accountant, an MBA, or a person who has a fair knowledge about the working of the corporates, like a vice president of a company, or a partner in a good law firm or a chartered accountant firm. Why can't they become at the age of 45? And I am also not happy that the rule saying that the appointment have to be contractual for a 5 years. Even the Companies Act says so, that even if it is for a period of 5 years, that 5 years is a renewable for another period of 5 years and another period of 5 years. So, if there is an assurance, it will have two things. Number one, that he will think of making a career as an insolvency judge. Number two, he will have a sense of belonging to the institution. He knows for sure that he is not going away he joins at 45, he is not going away at 50. He knows that he can retire at 65. So, at 45, if he is appointed, he will renew every 5 years. And if you find that such a person is incapable or unfit to be a member,
You don't renew him.
you don't renew him, or otherwise also the Companies Act provide a procedure that there can be an inquiry, and inquiry has to be by a committee to be followed and chaired by the nominee of an Honorable Supreme Court. So, if there is such a strong system that a person who is unbecoming of a member of the National Company Law Tribunal, you can always either not renew or you remove. But I am very unhappy with this situation, and that is my one suggestion to all, whosoever is the power that be, that don't take that short shift attitude in appointing the members. Don't make it a dumping ground for retired people. Take professionals at the age of 45, at the age of 46, appoint them for 5 years, no problem, until the Companies Act itself is amended. Like in US. In US, the insolvency judge is appointed directly for a period of 14 years. So, they have a sense of belonging, they have an assured tenure, and if they are unfit, they can always be removed. So, my one suggestion which will make, and I am telling you that even in the present circumstances, I am repeating myself, I am reiterating my views, that National Company Law Tribunal is one of the most important tribunal in the country, and it has done a wonderful job. The Companies Act 2013 has taken a slight back seat because of the overwhelming number of the insolvency and bankruptcy cases. They have shot at least 10 times more than the company cases. So, I can understand that in the 5 days a week, 4 days are going to the insolvency matters and only 1 day is left for the company matters. But if we can have the members at a young age with an assured tenure and with a sense of belonging, I have no doubt in my mind whatsoever that NCLT will do a wonderful job.
Now, let me focus another. While the process is on, and sometimes it takes time, the assets or the CD, how do you protect the value? How do you make sure that there is no erosion of value of the assets? Because that's important to the CoC, important to the.
I see what you are arriving at, and I think this is the concern of many people who are saying that there should be a cutting in the time lag of the decisions, correct? But I am not worried about the time lag. See, the moment a professional takes over the working of the CD, the CD's working is not dismantled. What is displaced is only the board of directors. The board of directors' powers are vested in one person, which is known as the IRP or the RP, correct? Therefore, the institution remains as it is. It has all its employees, it has all the plant and machinery, it has all the raw material, it has all the finances, and the RP has the power to take sometime without the consultation with the CoC and sometime with the approval of the CoC. He can take all decisions to run the company as it was running prior to the admission of the petition. So, I do not see that there is any cause of concern in losing the value of the assets of a going concern. So long the company remains as a going concern, which is the mandate also of the law, there could be some issue that once the company stop functioning, that its working is stopped and therefore it's going into liquidation. I can understand that the liquidation process must be faster, which in any case is faster because they have said that not more than 12 months should be taken in the liquidation.
Isn't it 12 months also too long?
I don't think for a really for the larger companies, manufacturing companies. I can understand some service provider may disintegrate.
Yeah, because of financial services, because it's not tangible asset. So you're right.
I can see, but number one, financial services are not covered by IBC. Okay, neither the share companies. So the only companies which are covered are the service providers or certain small MSMEs which are operational creditors who can be taken, that is, who are service providers. So all those small manufacturing companies, service providers, I can understand that in the liquidation 12 months may be larger period. But then liquidation also sometimes takes time. It requires, you yourself say that there must not be a private negotiations. The rules provide that there should be a publicity, there must be an advertisement, there must be a full disclosure made, and then you must give a fuller participation by advertisement in the newspapers. Even at the e-auction which is now taking place, people are taking all kind of objections that in the e-auctions that the platform for the e-auction is sometimes based on the Wi-Fi, and Wi-Fi may not work, the instrument may not work, the platform may not work. So there are all kind of technical problem. I remember that in one cases the lawyer was saying that if there can be glitches in the NASA's instructions to the moon, then why cannot be there should be a glitches or presumed to be glitches in the e-platform auction. Now these are the practical issues, but as far as the going concern companies are concerned, I do not find that there is any apprehension in losing the value, and therefore this must be, I think, toned down slightly by the advocates of the cutting delays theory.
So for this episode, let me ask you the penultimate question. We talked about the role of the CoC versus the RP, whether the removal of the RP, and we've had cases in the past where the conduct of RP was not the best and the RPs were reprimanded also, right? They were removed and so on and so forth. How do you bring better? You already outlined that give them you bring younger people, bring professionals, give them a longer tenure, you outlined that. What do we do to bring better quality of RP?
See, I have possibly 3 or 4 suggestions in this regard. Number one, that when we started the whole process or the institution of the resolution professionals, or to find out that how the resolution professionals, all the 3 institutions run into it by rather rushed into it, and they established their subsidiaries, and immediately by a short process of 3 months training, 4 months training, 5 months training and a short exam, they granted the certificate. That has created a large number of the resolution professionals, and they were not all of a high category skills. Plus, not many of them were technically qualified. They were lawyers, chartered accountant, company secretaries, cost and works accountants, but not the technical hands. For example, if for a textile mill you have to find out an RP, I will be very happy if he is a B.Tech and a chartered accountant, and then he becomes an RP of that company. So it is that kind of skill plus the technical knowledge, and therefore this requires a constant upgradation. What is happening is that once you become a resolution professional, then there is hardly any time to update his skills. He is not undergoing any training. He is not improving upon his skills and knowledges. And that is the reason that the RPs today, on a shortest inclination, rather than taking a decision, they go and file an application for seeking an approval from the NCLT. So in one petition which is admitted, there are more than sometime 150 applications and all filed by the RP or by the objectors. So, the one case becomes 150 cases. This can be cut down if the RP can be educated and skilled to deal with these situations rather than running to the NCLT for further guidance or taking orders that no, I am fully protected if I act under the orders of the NCLT. That possibly should be cut down.
And possibly your last suggestion of giving them longer tenures, because there is a learning curve.
Yes.
Technically, you get better and better by being in the courtroom, by dealing and resolving such issues. So, that long tenure and re-establishment as a RP for 5-year tenure, unlike the US where you have 14.
No, that I was talking about the members of the NCLT. Right. As far as the RPs are concerned, they are at the whims and fancies of the CoC. Right. Once after 30 days an IRP is appointed as an RP, then he can be removed any time by passing a 66% voting resolution by the CoC.
So he or she is always.
So he is always at the pleasure of the CoC.
So clearly we know that, all things being equal, the CoC will have an upper hand, to put it mildly.
So that is what I was saying, that RPs is unfair to subject to that kind of a subjective opinion of the CoC always, because no reason is required to be given for the removal as of today.
Right. So that's another thing that needs to change.
So according to me, there has to be a reason for his removal, or what we call the just cause, as they are saying in United States.
Fantastic. My last question for this episode. You talked about the tenure of the judges, right, in the arbitration courts, right? And there are, right, the NCLT, as in the tribunal,
and the tribunal, yes.
Right, that's what I mean. Now, clearly they've come from lower judiciary, or they're technical members who have had some experience. What can be done in that aspect to be able to make this process?
See, I think if we look into and read carefully that what the two Honorable Supreme Court judgment, which I have earlier also given their name, is that Madras High Court Bar Association versus Union of India. Both the cases have laid down an elaborate list that what should be the tenure, what should be the skill, what should be the qualification, and what should be their status as a member of the NCLT. And they have elaborately said that when we are saying that there has to be a member technical, that member technical must also have a requisite experience. One of the example they have given is that suppose there is a person who has retired as an additional secretary in the Ministry of Water Resources. They are saying that how a secretary in the Ministry of Water Resources could be helpful to the National Company Law Tribunal. How he will help in giving a technical skill to the bench who is deciding about the company law issues or deciding about the insolvency issue.
But just to give a counterpoint to that, bureaucrats have very diverse set of assignments as they go through their career. So they tend to develop understanding, domain expertise through research, through consultation, and they have the faculty. I'm just giving you a counter view. Yes. So a bureaucrat moves from textile ministry to steel ministry, so on and so forth. So they are trained to be able to understand such things.
No, I don't think so. This is a judicial forum, and for a judicial forum you require two things. You require a domain knowledge, and you requires a kind of an instinct which is known as the judicial process. So you must have the judicial acumen as well as the domain knowledge. So according to me, your administrative experience as a bureaucrat is of not much use in the National Company Law Tribunal. Maybe in the Central Administrative Tribunal it could be of any use. But as far as the National Company Law Tribunal is concerned, it must have two requisites. It must have a domain knowledge, and it must have the requisite judicial acumen. Now, for a judicial acumen and to handle the judicial process, we always have a judicial member who is coming either from the retired higher judiciary, which is a very excellent choice. A person who has spent 15 years as a high court judge makes an excellent judicial member. Correct? Similarly, if you appoint younger, even let me assume that even at the age of 50 that you pick up a chartered accountant, but don't retire him at the age of 55. Keep him from 50 to 55, 55 to 60, 60 to 65. He will become a gold mine for NCLT after 15 years. This much I can tell you. So this is what is not happening.
Sure.
So I have nothing against the bureaucracy. I have nothing against the retired bureaucrats. But unfortunately, they lack that domain knowledge. They have a good administrative experience, but administrative experience is not required at the bench. At the bench is requires a domain knowledge. If you don't even understand that what is an equity share, what is a preference share, how the equity shares work, how the preference shares work, how your administrative experience will help as a company judge. Even as a member technical, you are a company judge. So technical member was supposed to be the expert of the domain, that even if the judicial member doesn't know the technical details of the subject, technical members must fill in. That is why I said company secretary, chartered accountant, cost and works accountants, they are the people. Or I can understand somebody retired as a joint secretary from the Ministry of Corporate Affairs. I can understand that person because he has a domain knowledge. He has dealt with the company's issues for a period of 3 years, 4 years, 5 years. Similarly, a secretary in the Ministry of Law and Justice, a person in the Ministry of Finance. So these, but that is why I gave you a completely extreme example of a secretary in the Ministry of Water Resources. Even if he is a good administrator, he has done a wonderful job in water planning in the country. He is of no use as far as a member of the National Company Tribunal is concerned.
As we close this 4th episode, if we had to sum up, the first thing was, how is the CoC vis-a-vis the NCLT and the RP and the CD, and you clearly have said that that process needs to be, it's working, but the CoC has an upper hand and it needs to be rationalized more, right?
Yes, correct. I think that it need to be reviewed to bring it more closer to the concept of justice.
Then you talked about the fact that the RP's relationship, with the CoC is certain kind. It needs to be improved, because the CoC has a power to either remove a RP or to reappoint an RP or let his or her tenure continue. And you feel that that doesn't work sometimes for the operational creditors, right? Because the RP then by definition tends to support the CoC's view, right?
Yes, correct. They are under a domain complete thumb, under the thumb of the CoC. This is what I don't like, any professional representative of the court being under the thumb of the CoC is not my idea of democracy.
And then you also said that the tribunal or the is doing a great job, but just ratifying, if I'm saying it, the decisions of the CoC or the directions, let me use the word directions or recommendations of the CoC should be in some way supplemented by a process where the recommendations should be verified on the principles of law, so to say.
Yes.
Just cause.
I will put it shortly is this, that don't take away the power of judicial review from the NCLT, even in the commercial decisions of the CoC. That is not fair to the NCLT.
And then you also talked about the fact that you feel that the assets, a lot of people have talked about the timelines and the process, that the process is detrimental to the value of the assets. How do you stop it from going down? And in your view, because the RP runs the company is still running, there is no erosion of assets. The company is running, the assets are there. So that's another view you have shared today.
And that is true about the most of the companies where we have seen a successful resolution. Like you take case of Bhushan Steel, you take case of Bhushan Power, you take case of SR Steel, you take case of any big manufacturing company which has been taken over. They are running successfully today.
Sure. And last is that you talk about the fact that even the judicial members of the NCLT, the judges, they should also possibly have a longer tenure.
Very much. I'm all out for it.
And you said that will ensure continuity, learning, and a deep sense of involvement with this cause.
Yes, belonging to the institution. If I know that I will be there for 15 years, I will put my heart and soul into it.
In this third episode of Understanding Corporate Law with Dr. U K Chaudhary, you heard Dr. Chaudhary's views on the relationship of the CoC with the RP, with the NCLT, with the CD. You also heard Dr. Chaudhary that there is a reset required, while the NCLT is doing a commendable job in making sure that the objectives of the insolvency process are achieved. He cited numbers, but once you watch this episode, you'll know that there needs to be a reset, and possibly the reset can help the process even better, can help every stakeholder. So keep watching, keep giving us your suggestions, and we'll see you on the fourth episode of Understanding Corporate Law with Dr. U K Chaudhary. Until then, goodbye.